A question that we're frequently asked, either by clients of the law firm or just people that we come in contact with that know that we're eminent domain lawyers, is what is eminent domain? And eminent domain is nothing more than the power of the government to take private property against the owner's will and without the owner's consent for a public purpose. It's an inherent power of the sovereign. It's an inherent power of government. The power of eminent domain is curtailed by the Constitution. The Constitution is a limit on the government's power to take private property. And the Fifth Amendment of the Federal Constitution, applicable to the states through the 14th Amendment, and Article 10, Section 6 of the Florida Constitution states that no private property can be taken except for a public purpose and with full compensation therefore paid to each owner. That's what we do. We litigate either against the government's right to take private property, or if the government does have the right and does acquire the interest in private property, we litigate the amount of full compensation. So the Constitution limits that power, and then practically the way that the eminent domain power is implemented is through specific chapters of the Florida statutes, Chapter 73 and Chapter 74. There are two different methods under which the government can take private property in Florida. Chapter 73 is a slow-taking process where the government files a lawsuit and then litigates the amount of compensation. And once that amount of compensation is determined by a jury, they elect whether or not to pay that amount. If they elect to pay it, they take title to the property. If they elect not to pay it, then they dismiss the case. The case is over, the owner keeps the property, and the government goes away. The second and more frequent way that eminent domain is implemented is under Chapter 74, and that's called a quick take statute and a quick take provision. And what that allows government to do is to take title to private property in advance of the payment of full compensation. In a quick take proceeding, there are actually two trials. And this is the most common form of eminent domain case that our law firm deals with. The first trial is a bench trial. It's a trial in front of a judge. There is no jury. And the judge makes the decision as to whether or not the government has the right to take private property. It is a very low standard that the government needs to prove to be able to take private property from an owner against his will. The government has to prove that the property sought to be taken is being taken for a public purpose, that it is necessary for that public purpose, and that they have made a good faith estimate of value based on a valid appraisal. That's it. If they prove those three things and they present witnesses that testify to those three things, they get the right to take the property. The judge cannot substitute his judgment or her judgment for that of the experts that the government puts forth, engineers, appraisers, etc. So if they prove those three things, public purpose, necessity, and good faith estimate, the judge enters what is called an order of taking. Upon entry of that order of taking, the government then has 20 days to deposit the amount of their good faith estimate of value into the court registry. The date of that deposit is the date the title to the property sought to be taken transfers to the government, and the constitutional right to full compensation vests in the property owner. It's that simple. That's how the eminent domain process works. Once the order of taking is entered and the government makes the deposit into the registry of the court and title transfers to the government, what's vested in the property owner is the constitutional right to full compensation. That's when eminent domain cases truly get interesting. Eminent domain is one of the most fundamental constitutional rights that any citizen of the state of Florida, or of the United States for that matter, has. There are two highly protected rights under the Constitution that require 12-member jury trials. Almost every trial you see in a courtroom is a 6-member jury. All the PI cases, all the contract cases, all the commercial litigation, all of that are 6-member juries. There are two 12-member jury trials, eminent domain and capital punishment, the taking of property or the taking of someone's life. And that's how important these trials are to the American way of government and to the Constitution and constitutional rights. I'll get to your question.
Yeah.
Another frequent question that we get is, oh my gosh, the government's knocking on my door, you can't fight City Hall. How would I ever be able to afford to litigate against the government? The good news is that Florida is one of a handful of states in the United States that zealously protects private property rights. The public purpose, as stated through the case law in the state of Florida, is that no private property will be taken without full compensation. That's the constitutional provision. What's important about Florida's interpretation of that provision is that full compensation in the context of Florida law means that all of the expenses incurred by an owner in defending themselves against the government are paid for by the government. The Florida courts have determined that if you have to fight the government and then pay a bunch of money for attorney's fees and money for expert witnesses, you haven't received full compensation. You've received compensation minus the expenses of obtaining that compensation, which leaves you with something less than full compensation. So in Florida, attorney's fees and costs, being expert witnesses, appraisers, engineers, land planners, CPAs, anybody else that we would need to present a case evidentiary to a court, is paid for by the government at the conclusion of the case. The attorney's fees are paid based upon the benefit that the attorney obtains for you. And that benefit is statutory. There's a statutory fee schedule that sets forth what the amount of attorney's fees will be. Before a government can file an eminent domain case in Florida, they are statutorily required to make an initial written offer to a property owner. Once the initial written offer is made, they have to wait at least 30 days before they can file an eminent domain lawsuit. The importance, insofar as attorney's fees are concerned, of the initial written offer is that it is the baseline measuring point upon which attorney's fees are calculated. So if they make an offer, for example, of $100,000, and our client says, well, that's completely inadequate, I think it's $300,000. And we then put forth a claim for $300,000. If we're successful in obtaining that $300,000, we have a $200,000 benefit, a $100,000 initial offer from the government, and the $300,000 recovered is a $200,000 benefit. Our attorney's fees are calculated by a percentage in the statute of that $200,000. So 33% of the first $250,000 benefit awarded is calculated for attorney's fees. So that would be a $66,000 attorney fee. The beauty of an eminent domain case and the constitutional protections that you have in eminent domain is that, unlike a personal injury case where you would have to pay the attorney a third of that recovery, that is paid separate and above the award to the property owner. So if full compensation is $300,000, $300,000 is what goes to the property owner. The government then has to pay $66,000 in attorney's fees in addition to all of the expert witness costs. And again, expert witnesses can be engineers, land planners, real estate appraisers, CPAs, arborists, drainage experts and engineers, environmentalists, a myriad of other folks that may be needed in any particular case depending upon the issues that arise in that specific case. So the expert witness fees are paid on an hourly basis as long as those fees are reasonable and necessarily incurred in the litigation. So, in a nutshell, the design of the Florida statutes, which is very property rights friendly, and the design of those statutes is to put a property owner on equal footing with the government that has inexhaustible resources and finances because they have an inexhaustible power of taxation. Government has unlimited funds to litigate against you. And fortunately, as a Florida property owner, the Florida statutes state that you're going to have the funds to fight them back because they're going to pay fees and costs.